Hello and welcome to my webinar, Hoarding for Housing Lawyers, where we're going to consider the legal framework and the mental health considerations required when litigating for hoarding matters. I'm Sarah Christie, a legal director at Capsticks. So today the aim of the webinar is to look at an overview of the legal remedies available to social landlords, and also to look at the mental health considerations that you will need to take into account. So the referrals that you will need to make, practical considerations, and how decision making is evidenced as well. So first, looking at the legal remedies for social landlords. Firstly, in the Social Landlords Toolkit, to deal with hoarding situations is a breach of tenancy injunction. So as a lawyer, you will need to first of all check what the terms of the tenancy agreement are. We will need to see whether there is a breach of that tenancy and whether we have the evidence to be able to show that breach. Firstly, we come across quite regularly breaches of access terms of the injunction, whether those are express terms within the tenancy agreements or the implied terms implied by Section 11, subsection 6 of the Landlord and Tenant Act 1985. In addition, we might be looking at terms in the tenancy agreement that deal with property condition. Have those been breached? And have we got the evidence that those have been breached as well? So, for example, photographs of the property or videos of the property as well. So we can evidence to the court that those terms have been breached. We might also be able to see in the tenancy agreement whether there are any terms relating to the communal areas. Are there terms relating to rubbish being properly disposed of or items being left in the communal areas? If so, we will need evidence to be able to show that these are being breached by the defendant.